Evening, everyone. Welcome to this special panel Q&A. My name's Ben Handy. I'm a personal injury barrister and currently head of pupillage at St John's Chambers. This evening, I've got the easy job. I'll be asking the questions and I haven't even had to think of them because they've been sent in by you. I can see there's a lot of you with all the variety that brings, but what you all have in common is an interest in a career at the bar and we hope maybe at St John's Chambers. Thank you for all your questions. Reading through them in preparation for this really stopped me in my tracks. They are thoughtful, insightful, and they suggest that quite a few of you are already deadly cross-examiners. I'll do my best to ask as many as I can. We hope that this will give you a chance to gain some insight into a career at the bar and at St John's while lockdown makes traditional minis impractical. To answer your questions, I've got a fantastic panel with members from all of our main practice areas. I could embarrass them by talking about how brilliant they are, but they'll do that for themselves. So I'll limit myself to saying that I'm as intrigued to hear their answers to your questions as you are. If I can ask them to give a little wave when I mention them, we've got Bethany Scarsbrook from our family team, Rob Mills from Clinical Negligence, Natasha Dzameh from CNC, and finally, but definitely by no means least, we've got, I'm excited to say, Annette Bushell, who's our personal injury practice group manager and our longest serving clerk. I hope she doesn't mind me disclosing that it's approaching 20 years now. So she has helped pupils and junior barristers alike become QCs and judges, and she personally clerks some of our senior, our most senior successful members. I'm particularly happy to see Annette because she isn't working at the moment as she's undergoing treatment for breast cancer. So we're delighted to spend a bit of time with her this evening. We all miss her, but she's well and she's delighted to be joining us to give you an insight into her role. I should say finally, before we get going, that at the bottom of your screen on your toolbar to the right-hand side, you'll find a Q&A button. If you click on that, you should be able to type in any further questions that occur to you during the course of the session. Okay, Annette, I'd like to start with you if I may and ask this, because some of our listeners may not know, but what is a clerk's role?
What is a clerk's role? Basically, the clerk's role is to support and guide the barrister. If we take a team of barristers, that's one thing, but there's also all the individuals within that team. And it's for the clerks to ensure that they're doing the right level of work, directing our professional clients to barristers who they may not know, but who are suitable to do the work that they want them to do. We obviously, from the outset with pupils, we're guiding and making sure that they're doing the right thing at the right time. And that works all the way through the barrister's career. So we have a very close relationship with counsel. We're not just there to book things into diaries, we're there to help advise on career path, advise on solicitors and professional clients who it will be very beneficial to know depending on which way you want your career to go. And obviously to help with any issues, if there are any hiccups or things that need sorting out, then we are the diplomats that deal with that.
A bit of carrot and a bit of stick.
Yeah, absolutely. Absolutely. Every now and again, somebody needs a wallop with a stick, but it's not very often, to be fair. Most of the time, I think we work well together.
You've seen a few barristers, Annette. In your view, what is it that makes a successful barrister?
A successful barrister? Well, so the legal knowledge, obviously, let's say that's a given. Okay, so the legal ability is there. Real commitment, enthusiasm. Clients want to know that it's something that, as a barrister, you are interested in. And that's professional clients and lay clients. They all need to know that you are committed. Responsiveness. If you get a call or an email from a solicitor, then your response is crucial, the timing of that response. Even if you're just saying, I can't get to this immediately, do it. because then you've engaged with them, which is a great thing to be doing, because that helps to build and cement that relationship. But more to the point, they need to know that you are addressing that work and when you're going to address it, because they have a client sitting behind them, which may be a lay client, it may be an insurer client, but they are going to have expectations. They will want to know, and they will be hassling your solicitor until such time as they get to hear what's going on. So responsiveness, really important. Solicitors absolutely love it. People skills are very, very important. You might say, well, that's obvious, but if your legal skills are there and you're highly capable, the human quality that you bring to your professional life and to the relationships that you build within that is absolutely crucial. You know, all things being equal, people want to work with someone they enjoy working with. People want to work with someone that they like, someone who can respond, somebody who is a team player. That's a very important quality as well, because from counsel, they do want to know that you're all in it together, but they also need to know that you can lead the team. And you don't, I'm not talking about being a QC necessarily and doing that. Right from the outset, you, your professional client, your lay client, that's the core of the team before you even get to experts, etc. And they want to know that they can have faith on you guiding and leading that team. So I think that's very important.
Why don't you tell us a little bit, Annette, about how you got where you are? What was your route to the bar?
Me? Oh, well, I worked for a firm of solicitors doing crime many, many years ago. And through that, got to know barristers, got to know chambers, and a job came up at St. John's Chambers. And a friend of mine gave me a nudge and said, why don't you give it a try? So I applied and I got the job, and that was 25 years ago. So I ran the crime team for 12 years, and now I've been running PI for 13.
Yeah, you do really get less for murder, don't you?
Oh, absolutely you do. No doubt about that at all. Yeah.
Okay, let me turn to you, Bethany. Why don't you tell us a little bit about your route to the bar?
My route to the bar is quite boring and conventional. So I knew that I wanted to be a barrister from about the age of 14, but if I'm honest, I don't think I really knew what that meant. By sixth form, I had a bit more of an idea, and I also was very clear I wanted to do a law degree. So I read law at Oxford, and then immediately was still going on the motorway route, went straight through to do the bar in London, and applied for pupillage when I was on my bar course. But of course, pupillages recruit a year in advance. So I secured a pupillage in London, but had a year to fill. And having said I was done with exams and would never do any more, I voluntarily went back to Oxford to do the BCL to fill my year. So I did that and yo-yoed back to Oxford, then back to London for pupillage for a year. Had a really great experience in London at a family set, but ultimately wasn't quite the work that I wanted to do. I wanted to do a broader range of family work. And so I applied to join St. John's as a third six pupil in 2016, and I was made a tenant at the start of 2017.
Great. Natasha, why don't you tell us yours?
Pretty traditional route as well. So undergraduate degree was law. Then I went straight to do the bar course. Realised once I was getting towards the end of my bar course that pretty much everyone who seemed to have been taken on at a good commercial and chancery set in that previous kind of year or two had a master's. But then was thinking, well, now I don't have any money to pay for a master's. So I went to work in a law firm for a year doing personal injury and insurance cases. Then I went back and did a master's in international commercial law, and then spent a few years working as a county court advocate, and then got pupillage at St. John's.
Okay, and then finally, Rob.
So my route, Ben, started with a philosophy degree, and that was the thing that had interested me at school. Probably the only thing that interested me at school, to be honest, was philosophy. I loved it, so I did my degree in it. And as I came to the end of it, thought that I need to obviously go into some career path, but I'd had enough of philosophy to the extent that I didn't want to be a professional philosopher, and the bar fed really nicely into that. It's an example of a non-law degree, I suppose, that feeds really well into it, because it teaches you to argue effectively. And having decided on that path, I then took a gap year after university with a view to going on to doing the GDL. But in that year, what I wanted to do was try and build a CV that I thought would help me in those law applications, because as everybody watching tonight will know, it's so difficult to spend the amount of time required to fill your CV with the kind of things that are wanted. So I did mini pupillages and those kind of things, but I also tried to do some life experience things. So I worked in a bar in Paris for 6 months, and I worked in Brazil for 4 months as well, in a company that did international trading. So it had nothing to do with law at all. But those were the two things that I always got asked about in my pupillage interviews: the work in Brazil, and even more than that, the work in the bar in Paris. Because frankly, it's the things that they're a little bit different that you often get asked about. So don't rule things out, I think, just because they don't necessarily seem law related. Had another year out by necessity because of the year in advanced recruitment, and then I came to St John's, where I've been ever since, very happily.
Well, I know you're good at arguing, Rob, so that philosophy degree obviously worked.
Good of you to say.
Interesting question here, and I'll open it to anyone. How would you explain your role to a new client who knew very little about the law?
Well, I know what I'd say about mine.
Go on.
If they know very little about the law and they don't know how it works, I'd say being a clerk is like being an agent and professional parent all at the same time. That's what I would say.
That's a really good description.
Incredible, pithy, but actually explains it very well. Come on, what about one of the barristers? You're paid to talk.
I think if you explain my role, the answer is that it is none of my clients' plan A to be involved with me. And that's true for my lay clients and my professional clients. You know, when my lay clients were getting married or having their children in the hospital, I don't think they ever intended to be sitting in a room talking to me. So I'm always well aware that I was nobody's plan A, and I probably wasn't even plan B. And you know, then the solicitors hope they're going to be able to sort it out without going to court, because obviously family, we focus on trying to settle things without court resolution wherever we can. So I'm very aware that I am when people really need to go to court and they haven't been able to resolve things by any other mean. And so I always try to remember that when I deal with my clients. But essentially I deal with people's real lives, and that's what's so great about my job, is that it's not, some people will tell you black and white shipping contracts are the most exciting thing in the world, but I deal with people's real lives and their children and their family home and keeping all of those things. And so yes, it's the law and it's black and white and there are rules, but trying to fit someone's multi-coloured personal life into that structure is what makes my job really interesting.
Yeah, it's the people that add the colour, isn't it? Again, brilliant question. What is the worst experience you've faced with a client or barrister, Annette? Anyone got any horror stories that spring to mind?
I lost a case for a QC. Yeah, well done me. It was in my first 3 weeks in the job, and not only was he a silk, he was also head of chambers, and I got stitched up a good one. This is on a crime case. I really got stitched up by somebody from the as in the Crown Prosecution Service, and yes, they conveniently, because of something I said, whipped the brief away, because I had given them the impression that, well, no, they decided to take the view that my barrister was not available, whereas in actual fact the barrister was going to be available. But yes, so I lost him a prosecution silk brief, and I thought, this is it, my days are numbered. But he was very gracious and didn't sack me. Yeah.
In my very first week as a pupil, I was in a court hearing and conference beforehand with one of the most senior solicitors in the country for family finance work. And they said to my supervisor, can your pupil, I didn't have a name, go and get us all some coffees? This was in a court that was miles away from the coffee shop. So I ran off and came running back with my 7 stacked coffee cups and got back to court, and they'd all gone into court. And I remember standing outside in the waiting room being like, what am I supposed to do? They've all gone into court and I'm standing out here with 7 coffees. Like, do I go in and offer the judge one? Like, what, no one tells you what to do. All of those degrees do not tell you what to do in that situation. So that was a good day.
It's all glamour, isn't it?
Yeah.
All glamour. Anything from you or Rob or Natasha?
I don't have sort of a specific horror story in mind, Ben, but a really hard situation that comes up with clients not infrequently is in my clinical negligence practice where they don't have a case. And this is a person who's probably been hurt quite severely in some way. Sometimes they might be dying. Is it that severe, the situation? And you have to turn around to that person and say, look, I'm sorry for what's happened. It's terrible. But ultimately, when you apply the legal arguments to this case, it doesn't stack up. You're not going to succeed. And the fundamental message reading between the lines is this isn't going to happen. You're not going to get any compensation. Go home. And the reaction to that can sometimes be admirably understanding, but more often than not can be anger. And that anger is directed at you as the barrister because you're the one who's making the assessment and giving the hard news. So yeah, I've had several people who go into a rage at me and shout and scream and F and blind at me. And that's a reality of the job because you're dealing with people with high emotions who are badly hurt. It's one of the reasons I like clinical negligence, that there is that emotional side, that you do have the people element, but it can certainly be difficult on those days.
Yeah, whenever it invariably does go wrong, because it's going to happen on occasion. I don't know if you're like me, but you sit there and kick yourself about what the things you didn't say or the things you didn't do to maybe explain things better earlier on in the conversation, and you can just see it running away with you. You're replaying it time and time again. Which leads me into actually another good question. Do any of you not suffer from imposter syndrome? Is probably a better question. Bethany?
No. Oh, I am the queen of imposter syndrome. I had a panic last week, and Natasha was privy to that. I worry all the time, like all the time. But I think everyone does. That's what I have noticed about that. Natasha might be the only person who doesn't, but I definitely do.
It's funny, isn't it? You see all these brilliant advocates in court, and just feels like they're doing a different job, doesn't it? Much easier to give other people credit than it is yourself.
But then that's just part of acting is part of the job. You are there to present a case, and I think we have to remember it's not about you, it's about your client. And so when you're focusing on presenting their case, then hopefully your fears about yourself come secondary to that, because you need to be focusing on them and their best interests and doing your best for them. You don't really come into it.
People are much better at talking about these kind of things than they were, aren't they? Feels like that's been a gradual change in that direction since I started.
I would agree with that. It's the sort of thing that comes up more now in practice reviews.
Right.
I'm not very good at pushing myself forward type affair, and really I feel like I'm being a big con artist most of the time. These are sorts of things that you do hear from people who ostensibly seem to be incredibly confident and full of all the strengths you need to stand up and put up a good show. But it's surprising, everybody has their insecurities, don't they? And I think part of the relationship between the clerk and the barrister is ensuring that the barrister's practice development supports their how can I put this? supports their desire to get on, but also does push them out of the comfort zone a little bit, because I think some need that rather than.
But not too far, I guess. It's finding that balance.
Yeah, it is a fine balance. Yeah.
So do you have those discussions as clerks, or just do you think about it as a clerk when you see pupils coming through the door and starting second six?
Mm-hmm.
Do you actually think about what kind of work you'll give them and what you won't give them?
Yes, most definitely, because it's a career stopping move to dump something on somebody who is just not ready for it. You know, it's a bad day for a clerk to do that, but it's career stopping potentially for that barrister. So that sort of thing has to be very carefully managed. And you also get something which I refer to as like it's a sort of halo effect, where somebody has got a very good result for a solicitor or professional client, and that client may be so thrilled that they want to send them a reward, which is another case, but perhaps that case might be just one step too far for them at that time. And it's that's where the clerk has got to be assertive, provide clear guidance to counsel, and just ensure that they don't take on more than they are at that moment in time ready to deal with. And if that's something that needs discussing with perhaps their pupil supervisor or ex-pupil supervisor, or someone that they senior that they look up to, then so be it, that they can do that. But ultimately the decision has to be for tenant with the tenant, but for the pupil, yes, we need to be careful with that sort of thing.
And clerks have a huge amount of power, don't they? Particularly over junior tenants, junior and pupils. You know, if they aren't careful with that, then they can create an awful lot of stress for someone who's already worrying about starting a new career and panicking about every tiny thing they're asked to do. Absolutely. You know, it might be sending them around the country to 5 different far-flung places and not leaving them any time to breathe. You know, we're very lucky at St John's that it doesn't strike me, I didn't do pupillage there, but it doesn't strike me that the pupils are asked to do stuff that frankly the clerks wouldn't be prepared to do themselves. That seems to be the touchstone. Yeah,
I would agree with that. You've got to respect the fact that you're dealing with human beings who are at a very, very stressful point in their lives with their careers, and having to think about making a good impression on everybody they come to, like on permanent show, and it's our job to support them in that and not to crush them. That's an absolute no. There is no abuse of power. That will never be tolerated.
We talked a little bit about sort of bad days, but what about the good things about your job? What do you love about your job, Bethany?
Winning.
Good.
No,
I love the point.
I love the days where you're in court and just everything is going your way. So some barristers really look forward to cross-examination. It's taken me a long time to not feel physically sick before cross-examination. But actually, you have these times where you've prepped really, really hard and everything just comes together for your case and the client on the day, and the judge is with you and you have the answers to everything, and it all just slots into place, and that's just fantastic. And you really have to remember those moments when working very, very hard.
I remember we were going away, a few of us, on a trip to Botswana, and shortly beforehand I had a trial where the person who I was cross-examining, having made quite a big deal about how religious she was and how keen she was to tell the truth and how she'd never ever tell a lie, told about 4 lies in a row, which almost never happens that you catch them out in that, especially consecutively. And it was just brilliant. I thought, this is the best bit of cross-examination I've ever done.
Rob?
I think for me it's being self-employed. I love being self-employed. I love the freedom that self-employment brings, that I can choose my own working hours, choose how much holiday I have. I've got small children, so I'm at a time of life where I want to probably have more holiday than I might do at other stages of life. Clerks are understanding about that, and I'm not in a firm where I'm work to the grindstone at all hours for a set salary. I get out what I put in. I think it's absolutely fantastic. I mean, I'm used to working from home, so this pandemic hasn't changed that much, but equally it's nice to be able to go into chambers when you want to see people, to discuss cases. I can't speak highly enough of self-employment. You have to be organised, it's probably true, but as long as you've got a basic sense of organisation and get yourself some good systems in place, I think it's one of the great benefits of being at the bar as opposed to being in a solicitor's firm or any other kind of firm for that matter.
It's a blessing and a curse, that flexibility, isn't it? Because there's always more work you can do on a case, always. And learning where to draw the line and when to pack up for the day is not easy. It took me a long, long time. Still not sure I've cracked it. But yeah, it's certainly nice when you can book out a chunk of time off somewhere far in the future and go somewhere fun, isn't it, Natasha?
He's only saying this because I take off quite a significant amount of time in one go.
There was a question actually about whether you get the chance to take free time and also to enjoy traveling, and you've had quite some good trips recently, haven't you?
Yeah, I went to, so last year, year before even, went to Italy, and then a few months later I went to Japan and then Botswana, and then I went back to Japan in March of last year, which was supposed to be for about 5 weeks, but I had to cut that short, so I had 3 weeks because of COVID. And the original plan had been that I would then go to Korea a few months later and then to Hong Kong. But instead, I managed to get a sneaky trip into Switzerland, but that was about it. So yes, you can have a fair amount of holiday. It's just a case of making sure that when you're at work, you're reasonably efficient. But there's nothing to stop you if you want to book off 3 months, then go for it. I wouldn't suggest booking that off all in one go because your solicitors will wonder where you've gone, but you can quite easily take off a month.
Yeah.
There's a question about what's the best thing about working for St. John's, and why don't we start with you, Annette?
Oh, the people, without a shadow of a doubt. From all the barristers, all the staff, fantastic group of people, and I wouldn't have been there 25 years if it wasn't for that. Very supportive chambers. For everybody. I think it's a fab place to work, and I love it. Really love it.
Rob?
It's probably the same answer. I won't repeat it because Annette's just said it, but yeah, I love the team that I work with. But aside from that, probably another answer would be that you get to be a specialist straight away at St. John's. There are chambers, and it's not a criticism, but there are chambers where you have to sort of be a bit of a jack of all trades for quite a long time. Whereas all I've ever done is be a specialist in the area I want to specialise in. And that makes it an awful lot easier because a barrister is ultimately supposed to be an expert in terms of when we're advising our clients. And you try and be an expert in 5 different areas of law with new cases coming out every day. And the scenery changing is really very difficult. I think probably what the market demands, certainly out here in the Southwest, is specialism if you want to be successful and do the best cases for the best solicitors. So the fact that St. John's allows that from the outset, and indeed it's the only option from the outset, I think it's really good.
You're primarily clinical negligence now, aren't you, Rob? Are you entirely clinical negligence? So
I do some PI trials to sort of keep my trial hand in, because there's not much trial work in clinical negligence. It's, a lot of it settles, a lot of it's paperwork. So I do some PI for trials, but essentially I'm more clinical negligence.
And remind me, were you 2013 call?
2014.
2014. So how early on was it when you felt comfortable saying, it's clinical negligence I want to drop PI, for the most part at least?
I sort of started out with that to a degree. Not that I want to drop PI, because it's really important to do lots of trial experience when you're coming into the profession to get your advocacy up. But I always wanted to be a clinical negligence specialist. I did for the most part, a clinical negligence pupillage. My pupil supervisor was a clinical negligence specialist. And so most of the work I did on pupillage was that. And it's that interested me. And a great sort of accolade of the clerks is that I made that clear to them as a pupil and coming into junior tenancy. And they went out of their way to give me excellent opportunities to impress and work for the teams in the Southwest that were going to give me the ladder up, which I did. But were not at St John's that had the connections into those solicitors, it's very difficult to get started. So the answer to your question is at the outset, but greatly aided by the connections in the first instance, and then you obviously build your own practice from there.
I can certainly say this year we've got 3 pupils due to start in April, and part of the process as they are approaching their start date is me asking them what are they particularly interested in within their practice area, because family covers a huge area, so does Chancery and Commercial, PI and Clin. In theory there's so many different things you could specialize, and we do try and ask people whether they want to be more of a generalist or a particular specialist, and then match them with a supervisor that has a practice in that area, and obviously contacts in that area they can introduce them to. Okay.
Can I raise one other benefit of St John's that's particular interest, I think, to the females among us? So having worked in London and in the regions, St John's is run like a modern business. It's very modern in its approach, and I think that's of a real benefit to female barristers and anyone with a primary caring role at home, because I think if you just look particularly at the family team, at the number of incredibly successful senior women and female silks in our team, that speaks for itself. And I think that equality is due to the modern and egalitarian way that St John's approaches everything.
Good point, and good to hear as well.
Yeah.
Certainly as far as pupillage goes, we do our absolute best to make the process as transparent and fair as we can. But I'm under no illusions that it's nothing's perfect, and we need to keep trying to improve things. Should we talk about COVID? Everyone loves COVID, don't they? How's COVID affected your practice, Natasha? Let's start with you. You're in C&C, aren't you?
Yeah, I mean, when it kicked off initially, basically what happened is all the hearings just disappeared. There wasn't that much paperwork for, I'd say, about a month or so. And then there just suddenly seemed to be loads of paperwork, and gradually the hearings have come back. Certainly before Christmas, I was doing an average of 3 a week, which is quite a lot for C&C work. So, I mean, ultimately, the upside is I don't have to travel anywhere. Everything is dealt with over video. So I prefer remote mediations, remote conferencing, all of that stuff. I'm quite a big fan. I haven't become someone who works paperless yet. We'll see when that might happen. But it would seem, certainly in terms of C&C work, there is more work than there was before, and we're expecting that there will be more insolvency work and more property work. So in a sense, it's a good thing. Downside, obviously I haven't been on holiday yet this year, so but other than that, it's fine.
Don't get to hang out with me. Seriously though, on the downside, not seeing friends and colleagues is strange, isn't it?
It's the biggest
one of because one of the traditional perks of the bar is that collegiate atmosphere, and that's not a myth. One of the beauties of everyone being self-employed is you don't have those tensions you might have in an employed office, where if X or Y next door to you isn't pulling their weight, and you're vying for the same promotions, whatever it might be. We all work with each other, but we don't have that sort of tension. If Rob isn't doing his job properly, he always does, but it doesn't directly affect me. And so actually it's a really nice environment to work in and to make friends in. But that definitely is taking a hit, isn't it, at the moment, just because people aren't seeing each other.
Yeah, it is taking a hit. I hope that when this is all over, whether that's by vaccination or whatever, that we will return to similar to how we were, and that people will still come in. I think the difference is that a lot of people who'd never worked from home before have now been forced to work from home, so they realise they can work from home. So I'm just hopeful that people do still recognise the benefits of having that collegiate atmosphere you described, Ben, and come back in. I certainly will do. But I know there's a lot of industries where people are now being encouraged and companies are making people work from home to a degree. So we don't have that force upon us. So hopefully the bar will be insulated from that and people want to come back.
I think everyone's itching to see each other, aren't they? Hopefully people will still want to come into chambers, and maybe when they do come into chambers, they'll see it as more of a time for socializing, bit of networking with each other, that stuff, rather than just sitting down and getting your head in the books. So it might actually be for quality time.
Mm-hmm.
Yes.
What about family work, Bethany? How did that get hit by COVID?
So different bits of family law were affected in different ways. So broadly speaking, you have financial remedies, which is people's finances on divorce. You have private children, which is people arguing about where their children should live or how much they spend time with the other person. You have care work, which is where the local authority involved in proceedings regarding a child, and domestic violence. So those are the four main areas, and they're affected in very different ways. So initially the courts panicked before we had the remote hearings up and running, and a lot of the finance work was adjourned and vacated, and there wasn't much of that at all. The care work pretty much carried on because it had to, and in that period immediately after COVID hit, I primarily did a lot of domestic violence and not much else. Finance practice went very quiet for a while. Pretty much now all the family courts are successfully operating remotely. So before Christmas, I did a really serious fact-finding hearing in private children with really serious allegations of physical abuse, sexual abuse. And I was a convert. We had so many different witnesses, so many parties, all remotely. And it was fantastic because you could watch everyone's reactions on the screen. So actually, I found it a really positive experience. And I didn't have to drive for 3 hours a day on top of all the prep. So ironically, now, in terms of children work, we are busier than we have ever been. We have so much work. We've actually got more work than we had before. The finance.
Pausing there, Beth. Is that because is that because of the obvious that the strained families are under? Due to the pandemic.
I don't think those cases will have got through to us necessarily yet. I'm sure those are all with the solicitors, but they might not have come through to us yet. But it's more there'll be some urgent stuff that will have come in because of family strain, yes. And also it's that we have a huge backlog from when the courts shut down. But a lot of family cases are very urgent and we have to keep going. So it's just that there is a very, very big backlog now, and the finance work is all back up and running as well. But certainly my practice, I do finance and private children. I'm still doing more children work and less finance than I was before COVID. But yes, we are incredibly busy.
I think I'm right in saying that the balance has tilted so sharply away from stuff arriving in chambers in hard copy. It used to be sort of 95% in hard copy and 5% electronically, and now it's almost the other way around, isn't it, Annette?
Yeah, that's very much the case. Yeah, now
it's amazing.
Now the solicitors have got a grip on their remote systems, and we've got our remote systems, and it all links up together. You know, we are so much more paperless than we used to be. What council chooses to do once they've got the stuff sent to them electronically is one thing, but we've no longer got piles of stuff tied up and in pink string.
Yeah.
You know, it's all via email.
Because I remember even when I was doing my pupillage in Liverpool, not that long ago, but every evening after court, you'd have to go into chambers, grab your stuff off the back, then go home. But now, in theory, everything can just be sent to your iPad, can't it? It's incredible, really. So, Bethany, you said you quite enjoyed the shift to remote hearings, and you found it to be quite effective. What about sort of remote working more widely? By that I mean sort of working with tools and highlighting on your iPad and all that stuff. Is that something you do?
Yes, so I was actually paperless before. I went paperless in 2018 because I've got a dodgy spine. It changed my life at that point, not having to lug my enormous suitcase on and off the train, I have to say. And so for me, that hasn't really changed too much since then. With the hearings, I will admit I was quite skeptical. And when I had big evidence-based hearings, I was always like, oh no, let's go to court. I don't mind, let's go to court. And then, yeah, it took until December for me to realize that actually it's so much better, because when you're cross-examining someone, you can't see the other party's reactions because they're all behind you in court. Whereas when you're on the screen, you can watch everyone, and the judge will often pin the people they want to watch the reactions of. And actually, Mr. Justice Mostyn, who's a family judge in the High Court, said that he actually found it better because he could go back and watch bits of the evidence again, and he would have a full transcript of everything that had been said. And he actually thought that was very helpful. So I've definitely come round to it a lot more than before.
In terms of pupillage, we had a question about, I assume this is linked, but will it be harder to get pupillage in future? I can say that certainly on the Western Circuit, which is a vast area, lots of chambers, the news has been really positive. Numbers of available pupillages are consistent with before the pandemic. So in terms of availability, things are looking okay. In terms of St. John's specifically, we've got 3 pupils who were due to have started ordinarily in October. We deferred their start date to April. So they're 6 months behind where they would have been. But with that, we hope that things will have chilled out a bit by April and we can give them a bit more of a normal experience. And then certainly by the time our next round of pupils start in October, really hoping by that point we can be back in chambers more or less as normal. Who knows? I know that Daniel and it was Daniel and Kate, wasn't it, our pupils who were doing their second 6, just got on their feet when lockdown started. And so that must have been a heck of a shock for them. But Daniel was on our last Q&A webinar, and it's amazing how, people just adapt. He said he was busy. He was, as familiar with remote hearings and stuff like that as any of us were, because, frankly, he's a bit younger and probably a bit more tech savvy than a lot of people, but also this was stuff none of us had done before. So in a way, you're actually leveling the playing field a bit for pupils and more senior barristers. I don't know. Okay. What have been your career highlights or favourite cases? Bethany, you were saying earlier that you've had your case reported this week.
Well, the decision was made, yes, but it hasn't been reported yet. But certainly I have 2 favourite types of cases that stand out for me. In children, it's where I'm acting for a alleged victim of domestic abuse, and we have what's called a fact-finding hearing to determine if the allegations are true. And when you get findings for someone who's been abused, often over an extensive period of time and has been traumatized, those findings then go on to affect the rest of the case. So it feels like a very important moment. It's the closest thing I do to a criminal trial, if you like. So the stakes feel very high, because with a lot of things in family, there's no clear winner or loser. You get some points, you lose others, but in that it's quite black and white. I also really like doing relocation cases in children, deciding whether a child should move abroad or not. And on the money side, I really enjoy doing non-disclosure cases and acting for, it is normally wives, but let's not be too gender stereotypical, where the other side appear to be hiding the true extent of their assets. And that's always really important, because again, there feels like there's a lot at stake to show that the money exists or could exist to get your client a fair outcome. And those are the 2 sorts of cases and results that I really enjoy and have been some of my most rewarding cases, definitely.
Annette, what's been your career highlight?
Oh,
It's a long career.
Oh, goodness me. I would say I have it's not actually sort of a day-to-day thing, going and seeing some of my barristers become judges. That's really good. That you feel very proud about that.
Who was your first?
Michael Longman, and then Mark Horton, and obviously people becoming silk as well. But yeah, going to London and seeing the judges being made up was great. Really loved that. That's a great.
You get to go along to a posh building and get all dressed up and drink champagne and all that.
Absolutely. Yeah, and meet, you know, whoever it is swearing the judge in. You know, whether it's sometimes it's the Lord Chief, sometimes it's a particular. With Michael Longman, it was the godmother of his daughter, who was Dame Janet Smith. So she had she came from wherever she was sitting at the time and swore him in as a favour, sort of thing. So yeah, it's great. It's a lovely day. It's a lovely day. It's a very special day. It's a very real privilege to be there.
Natasha, we've actually been asked on the Q&A as part of this. So what's your favourite and least favourite element of the CNC bar? And why did you decide to go into CNC, which isn't traditionally an area that's that open to women, let alone people with minority ethnic backgrounds?
I think with CNC, it was one of those things where it seemed like a good way of combining a lot of different interests because it is so broad, but also there is no typical practice. So whereas if you're going to be a criminal practitioner or a family practitioner or personal injury, there seems to be, or at least you seem to be able to say, well, your practice is probably going to be made up of X, Y, Z. You really can't say that as a commercial and chancery practitioner. There are people who exclusively practice construction, people who do a lot of insolvency, people might do a mixture of property and wills and trusts, or professional negligence, property damage. So you can make that practice into whatever you want it to be. I liked the fact that it wasn't restricted in that way. But also because I did a law degree, the areas that I enjoyed the most were the commercial areas. So in my final year of my undergrad, almost all of my modules were commercial modules, and those I really enjoyed. It didn't really feel like work. So when I did my master's, I really enjoyed that as well. In practice, it does feel like work, but not in a horrible way. Because fundamentally what you're doing is, most of the time when you're being approached for an opinion on something, it is because it's quite intricate and quite technical. And a lot of the time it's on something where there isn't a reported case about it. And so it does require quite a lot of research and quite a lot of thinking about. So you can't say, well, it's not like work, but it is fundamentally enjoyable. In terms of what I dislike, I don't think there's anything that I dislike that's specific to my practice area. I think it's more so something which is just fundamental to being a barrister, which is the frequency with which you're instructed on things where your role seems to be to act as the cleanup crew. And so someone has got themselves into an awful position, whether it's the client has messed up, they've lied to the solicitor, whether it's the solicitor's messed up and you're going to have a chat about someone being professionally negligent. You're being parachuted in sometimes at the last minute or sometimes just into horrible situations that didn't need to exist in the first place. That kind of thing I dislike, but fundamentally you can't get away from it. In an ideal world, and I think it's the way certainly you're taught when you do your degree and when you do the bar course, you think that you're going to be presented with this case where your client's been honest with you the whole time, they've been honest with the solicitor's done absolutely everything they should have done, nothing's gone wrong. And that's just not how the real world works. And it would be nicer if it did, because your job would be somewhat easier. But ultimately, that's just not the way it is.
Have you ever felt discrimination because of your, I don't know, racial background or being a woman in CNC? Do you think that's unfair? That kind of, it's a sort of assumption I have. Oh, CNC is a tough area for a black woman, but how do you feel about that?
On a racial basis, I don't think I've really noticed. As a woman, definitely I've noticed certain things. So there's a few women in my team, and we've all had a chat, and there is a solicitor in particular who has instructed us, and we very much get the impression that he is really bad at instructing women. He just won't really listen to your opinion and talks over you the whole time, and then tries to take credit for all of your ideas with the client. And it's just a very weird dynamic. It's a kind of dynamic where when we speak to the guys, none of them have had that situation with this particular person. So we're all just like, oh, it's a bit odd. But in general, no, I think that in general, you do find that your opponents in commercial are a bit more cocky. And I think that's unfortunately just the way that commercial barristers tend to be. I don't know how much of that you can just lay at the door of, well, most of the men. But, you know, it's not something that I struggle with, so it's fine.
I saw you nodding, Bethany. Have you felt this?
I think it's interesting. I don't think I was ever aware of any sort of gender disparity in my life at all to the bar, which shows I was very lucky. But certainly what I noticed when I was first on my feet, and I mean, I was a 23-year-old pupil and looked even more baby-faced than I do now. So I was a very young pupil. I found particularly the older male opponents, it was very hard to interrupt them at the very beginning. And it, you know, they would talk over you and they would dominate the conversation. And it took me a good 6 to 12 months to be able to control that. And it was something that I'd not really experienced before. So I found that quite interesting, and I had to learn how to deal with that. Now it wouldn't affect me at all who my opponent was, whether they were male or female. And I don't think it's fair to say that the only aggressive confrontational barristers are men. That's also not true. So I think that was something I had to learn. But then whenever I come across someone who's being very aggressive and that's their default setting, whether they're male or female, I remember what Baroness Hale's pupil supervisor said to her when she was a pupil, which was that women didn't make good barristers, because to be a good barrister, you have to know when to fight and when to do a deal. And women will either always fight or always do a deal. So when I come up against someone who's being super aggressive all the time, I just remember what Baroness Hale's supervisor said to her, that it's about both and knowing when to do which. And that sort of is kind of my guiding motto when dealing with gender disparity, really.
I couldn't help thinking about Kamala Harris during the vice presidential debates, where she kept saying, "Mr. Vice President, I'm speaking, I'm speaking." And it was just a really effective way of taking the wind out of his sails. He could not keep talking without looking like an arse. Brilliant. How about you, Annette? You know, you're the senior clerk in the personal injury team, and again in an industry that was presumably overwhelmingly male when you started.
Mm-hmm. To be honest, I've never had a problem. Bearing in mind that I cut my teeth dealing with police officers and criminals.
My dad.
Yeah, and your father.
I won't say which he is.
No, nor will I promise.
Maybe both.
That I think I had very good grounding in being able to navigate my way through, and I have never had any major issues. You'll always get the odd one or two, but in general, I think things have worked out very well, and people give you respect if you earn it.
I like to think that this stuff is talked about now, and it would come out if there was a serious problem in chambers, and it would get very short shrift. I like to think that.
I think the only time as well, sorry, just to jump in, I've just remembered, I marshalled with a judge who's very senior, who will remain anonymous for this story. And we were doing a case, and they asked me at the beginning of the day, "Do you have a man in your life?" And I resisted the urge to say, "No, I have a woman," to see what they would do. And then they said, "Is it the right man?" And then, you know, we went on with the case, which involved a very wealthy individual. And then at lunchtime, the judge said to me, "The right man is, you know, of the very wealthy disposition of this profession." And I resisted the urge to say, "Or do that profession." And that was probably the most gender discriminatory conversation I've ever had. And it did take a great deal of restraint as a pupil to not come up with all those ungender biased answers, but I was very well behaved. But maybe in hindsight, I should have challenged it a bit more.
Before we move on to just a few pupillage related questions, Rob, there's a question for you here from Sam.
To say, Ben, yeah, thanks. I'd seen that they popped up. I think there's two for me.
Just for the just for people who haven't seen them, let me read them out. It says, "If you don't mind me asking, at what stage did you have children? And is it going to be difficult to manage a young family as a pupil, or are chambers supportive with personal circumstances?"
Yeah, thanks for that. So, so I've got two children. One we had just 3 months ago, so that's a new one. The one that's probably closer to this question is my son, who was born, I think, just after I'd become a junior tenant, so just after pupillage. Although I would say that actually our pupil last year, I think, had his child either during or shortly after the end of pupillage. So it's a relatively well-trodden ground. I think I can say with complete confidence that chambers, certainly St John's Chambers, would go out of their way to be accommodating with it. I had various other family issues in pupillage, which wasn't children, but had a similarly sort of an impact on, sometimes you have to leave chambers at unusual times to deal with things, etc. And it ultimately will, in the first case, be your individual pupil supervisor you'd go to these kind of things with and discuss them with. Mine were completely accommodating, and I couldn't have wished for anything else. So I think on an admin level, yes, there will always be support there if you've got a young family, and everybody appreciates that is challenging. And the answer to the question, is it going to be difficult to manage a young family as a pupil? I think the honest answer to that is it will probably make a pupillage year more stressful, because it's a stressful year. And as most of us know, one of the upshots of having babies is you don't get much sleep. And imagining doing the pupillage year without much sleep, I think it would make it more difficult. So I don't know if this question comes from a position of somebody who is thinking of starting a family or has a family on the way, or what. I think the honest answer is I probably wouldn't recommend it if you could postpone it until you were a junior tenant. But if that is the situation you're in, I'm sure you would certainly be fine at St John's in terms of the support you'd get, and I'm sure that it would ultimately be fine. I have another question, Ben. I'll just read it out if that's okay. It says, Rob, you mentioned the emotional area of clinical negligence work. Do you recommend forming an emotional bond with your clients or be desensitized in the interest of objectivity? The latter.
Good question.
Definitely the latter. Becoming emotionally involved with clients is not a good idea, and I suspect my colleagues in family would agree with me, that although you want to be empathetic and sympathetic as much as you can to people in difficult situations, forming emotional bonds is not a good idea, partly for some of the reasons that I discussed earlier, that sometimes they will become emotional with you and you need to remain the objective person, because your job is to give them legal advice at the end of the day. That's not an emotional task, that's a rational one. I recommend being sympathetic as much as possible to people in difficult situations, but always remaining objective and not letting your emotions get involved. And sometimes that can involve not working on certain types of cases. If you have something that's happened in your personal life that means you will struggle to be objective on a certain case, that could be anything from, if you'd experienced something like miscarriage in your life or suicide of somebody close to you, do you want to be then working on cases involving birth negligence or people who've committed suicide? Probably not, because you're very unlikely, well, it's an individual judgment, but many would not feel that they could maintain that objectivity. And then it takes that sort of strength and self-awareness to realise, at least for a period of time, it's better to let somebody else take the reins on that, because they'll do the clients a better service.
And if I could just step in there and say, that's something that, again, counsel and clerk work on together. And if the clerk is aware of that situation, it's not something that's discussed in the clerk's room, because obviously it's confidential, but it is something that if the clerks are aware of, they will do everything they can to ensure that that choice made by counsel is respected until such time as, if ever, they choose to change their mind.
Can I just say two things about emotional bonds? One is when you get asked a question from your client, and I still haven't come up with the right way to phrase the answer yet, but when the client asks you, you do believe me, don't you? And I've not yet found the way to answer without sounding insensitive, to give the answer, it's not my job to believe you. You know, I'm not here to decide whether you're telling the truth or not. I'm here to look at the case you're telling me, shake it about, see if I think it's going to stand up, how I can make it stand up, and how I can advance it to get strategically what you want in the long run. So I think that's quite interesting when clients ask you that from an emotional perspective. The second point is that not emotional bonds, but you do see things in the papers and you will experience things in evidence that are emotionally harrowing, and they do have an effect on you, whether it's pictures in the bundle, of injuries or whatever it is, does have an effect on you. But again, that's something that's acknowledged at the bar now as part of well-being, that sometimes facts and events in cases can have a sort of secondary trauma to you as the barristers dealing with it. So you need to be aware of that and know how to deal with it and address it. So there's those two different sides to dealing with emotion. Another thing that I have learned how to do is how to deal with clients having panic attacks, and having some basic understanding of emergency mindfulness and breathing techniques, and knowing how to get them through that particular acute moment. Having to do that on the phone in remote working is also particularly challenging, but knowing how to deal with someone when they are in such an emotional state, because you can't go to pieces emotionally, you're there to get them through it, and you've got to stay rational. And so knowing how to deal with that is something I've had to learn how to do as well.
It's a strange job in that behind the scenes, when you're not in court, your job is to advise. And then when you're in court, your job is to argue for their position. And they're not the same thing, are they?
No, not at all. And what I say to clients is I have two roles. One is that I'm your advocate. I'm a mouthpiece. You tell me what you want, I will go and fight for it 100%. My second role is to give you advice in conference. And sometimes that's difficult questions. And sometimes it's telling you things you don't want to hear. But I wouldn't be doing my job properly if I didn't do that. And it's balancing the two. And I think as long as the clients understand that you have those two different roles, and even if you have to have a difficult conversation with them, you will still then go and advance their case, whatever it may be. But you wouldn't be doing your job properly if you didn't do both sides of that. And that's what being an advocate and performing in court is all about, I think.
Okay, I'm conscious of time, and I want to spend 5 or 10 minutes talking about pupillage stuff. So before I turn to the next question and give you a bit of a chance to think about, let me think, what can I ask you to think about? What would your advice be? This will be for all of you in a moment. What would your advice be for aspiring barristers when it comes to applications for pupillage? And while you're thinking about that, I'll just spend a minute talking through some statistics, because we were asked for some. So we were asked how many applications for pupillage did we have last year? How many of those were BAME? And how many of those were non-Oxbridge? So I went back to our stats and did some mining. Last year, we had about 150 applications, which was a bit down on the average, but 150 for 3 places. Of those 150, 29 attended fee-paying school, which is only 19%, but that's against the general population of 7%. 7% of people go to fee-paying school, and 19% applied to us. So there's obviously a funneling effect going on there, which probably isn't a huge surprise to anyone, but nevertheless, there we are. On the plus side, I suppose that means 81% of our applicants were state school background. 11 identified as having a disability. Of course, some people would rather not say, but the people who were prepared to say, 11 identified as having a disability, which is 7.5% against 13.5% in the general population. 40 identified as an ethnic minority of one kind or another, against 27%, sorry, against the general population as of the last census, at least, which was a while back, 14%. So that's encouraging. And finally, 17 identified as LGBTQ. So that's 11% against roughly 7% of people in the general population. In terms of Oxbridge, I'm strange to say, I don't know. We just didn't mine the data for that. But I did have a look at our last few years of junior tenants, and 4 of our last 10 most junior tenants went to Oxbridge. You'll be interested to know perhaps that for those of you applying this year, for the first time, we'll be removing the identity of schools and the universities you attended, because we've decided as a pupillage committee that we don't think that is a great marker for how brilliant a barrister you might be. So you shouldn't worry too much if your background, in fact, you shouldn't worry at all if your background isn't Oxbridge. Mine certainly wasn't. Okay, I think the question I asked you or threw open was about what advice you would give to aspiring barristers for applications for pupillage. Why don't we start with you, Rob?
So I suppose that there's a number of basics that most people who attend a pupillage interview have on their forms. things such as mini pupillage and marshalling. And they're really good to have on the form. And they also are good for you as somebody looking at what kind of law you want to practice. Certainly I figured out what law I wanted to practice through doing a mini pupillage with a medical negligence barrister. So they're not just box ticking exercises to put on the form. They are probably the best way of figuring out what the job is actually like to do. I think if you go into them with that mindset, you'll get the most out of them. And so my other main tip, aside from doing minis, would be try and have things on your form which will make you stand out and be different. And that can take pretty much any form that you like, because everybody will have mini pupillages, or at least everybody who gets an interview will have mini pupillages and marshalling and have done mooting, which are all, as I say, good things to do, but you need to have something else on there. And I mentioned my experiences in Paris and Brazil, which I always got asked about and were non-legal. They were more basic things, like I run a wine society, barristers like wine, they always wanted to ask about that. I used to work in prisons teaching them how to do debating. I always got asked about that. Anything that's a bit different is likely to catch the eye of the interviewer and will be what puts you into the yes pile. You've got to do the basics, like getting your spelling and grammar correct, and having the, some good qualifications, albeit, as Ben has said, not specific to any particular institution, but good qualifications, good legal work experience, and some non-legal to show roundedness. And if you can have those things that make you stand out, I think that's the other sort of ticket into the interview room. Certainly for us also at St. John's, if you can give us some reason why you're committed to Bristol and the Southwest, that's a plus. It's not a necessity, because some people will not necessarily be able to give clear-cut examples, but if you can say, look, I've done a couple of mini pupillages in the Southwest, whether they're St. John's or not, you've at least demonstrated that you're serious about the Southwest, compared to somebody, say, not from the Southwest, who has no apparent reason why they would want to come here. So we're always keen to see that. I think those are my tips, Ben.
Natasha.
Read the form. Once you fill it in, read it, because you don't want to be saying to a chambers, oh, I'm really interested in undertaking pupillage there because I see that you practice in family, PI and CNC, and I'd really like to experience all of those areas, because what we offer is a specialised pupillage in one of those teams. You don't get to experience all the areas. So if you say that you want to experience all of it, right away you've showed that you haven't read the website, that you haven't looked at what we do as a set and how we train, which obviously doesn't give a good impression. It won't lead to a good score on that particular component of the marking scheme. Make sure that you've got the name of the right chambers in there. People will obviously be making many applications to many different sets. And we've all made the applications. We all know that a lot of it is a copy and paste job. Run back through it and make sure you're talking about that specific set and that you've tailored it to that specific set. It's fine to have the basics copied over from each application, but you do want to be fundamentally tailoring the parts about why that particular chambers and why that pupillage, and sometimes even why that practice area, if that set's got a particularly niche area of commercial that they're well known for. I would say don't worry about too much about the issue of whether you have links to the particular area, because I don't have any links to the Southwest and had done one mini in the Southwest and actually didn't apply to St. John's on the basis that I wanted to be in the Southwest. It was on the basis that I wanted to join St. John's. So for me, in answering that question, really what I talked about was why I particularly liked St. John's and what I thought being at that set would do for me in my practice, rather than trying to come up with some weird reason as to why I'd possibly want to be in Bristol when I'm from Yorkshire. So I would just say don't worry about that. As long as you can come up with a good reason as to why you're applying to that particular chambers, it really doesn't matter.
Beth?
Answer the question honestly. Don't give the answer you think that they want. Because, so for example, my husband had gone round applying for pupillage. He'd gone round twice, and then he was applying to do criminal law pupillages, and of course it's all the jokes, oh, don't do criminal, etc. And so one day I said, well, why do you want to do criminal? And he gave me this story about how when he was 15, he'd been beaten up by the bully's 21-year-old friend at the school gates with a crowbar and gone to the police and they'd done nothing. And it was about giving a voice to those people. And I was like, do you say this in interviews and on your form about why you want to do this law? And he said, no. And I said, what do you give? And he trotted out some trite answer that anyone would give. And I said, have you thought about actually putting this on your form and telling the truth? And they asked him about it in interview the third year round. He put it on his form and got asked about it a lot. And it was a genuine reason and a link. And it was about giving people that voice in court. And so don't just be the carbon copy that people think you want. If watching this has shown you anything, it's that we're all incredibly different. And there's no such thing as the sort of stereotype barrister. So don't try to be that sort of vanilla person. Give us the real reason.
Anything else that you want to add to that, Annette?
No, not at all. I think those are all very, very important and very clear points. Yeah.
It's definitely true. There are numerous ways to approach the job and plenty of room for different styles, different personality types. So you shouldn't be afraid to be yourself. And actually, if you're not being yourself, just to at least a large extent during interview, then you're making a mistake, because, you know, it's easy to say, I know everyone says this, but it's true. You know, it is as much about finding a place that suits you as vice versa. And you have got to spend the rest of your life there potentially. So it's an important choice for you as well as anything else. Just want to correct one thing Rob said, which is, well, I'm not sure if he even said this, but he said at one point that everyone who gets interviews will have mini pupillages. It's not strictly true. It's not one of our sort of must-haves. We have a section on our form for work experience, which might be legal and non-legal, paid and unpaid, might be experience of jobs, you know, work, or it might be work experience. So in fact, if you want to know our criteria, you can find them. Our pupillage policy contains really specific details about our process and our mark scheme and things like that. So if you go to the pupillage section of our website, you will be able to download that. I wrote it, and it would be lovely to know that someone other than me has read it. So have a look at that. And then just finally, maybe it might be a nice place to end. I'm really sorry we can't get through all your questions. There's so many great ones, and we'll have to do another one of these at some point. But one that really jumped out to me, and it's maybe another way of approaching the same question from a different angle, was if you could go back in time and either talk to your undergraduate self or your sixth form self, whatever it might be, and give them one bit of advice that you wish you'd known then, what would it be? Maybe I'll start to give you a chance to think. And I wish I had known in my first year of uni, in my undergrad, that tort law would be what I'd end up doing for the rest of my career, because I think I skipped most of those lectures or fell asleep through them or something, and I didn't have my notes. And so I wish I had known then that if I'm going to go into personal injury, if I'm going to go into stuff that requires that, just focus on that, because I had to learn it all again. Anyone else?
I think I'd give my advice to probably me before I started pupillage, rather than necessarily at an undergraduate stage. But the advice would be to see it as an experience to learn rather than a test to be passed. So I think a lot of the time I fretted about and stressed about ensuring that my aim of that year was to pass and impress and become a junior tenant. And that obviously is, the aim of pupillage. But ultimately, what it's really supposed to be doing is preparing you for practice, so that you can learn how to do the job well, interact with clients well. I know there were times where I would just switch off because I thought, well, this isn't really going to make much difference to me succeeding in pupillage, but it probably would have been helpful to listen just to learn how to be a better barrister. So treat it as a learning experience, not just a set of hurdles to be overcome, is my piece of advice.
First, I wouldn't say something to myself, but I would observe that I took the motorway route through qualifying and pupillage. And that meant I was incredibly young when I was a pupil, and I don't think I had enough life experience to be dealing with the work and what was required of me, and was probably a bit too naive at the time. And so with hindsight, I would probably have taken a more scenic route, taken a few more years, maybe done the BPTC part-time and worked at the same time, and not have been in such a rush, and then maybe have been slightly more mature when I got there. And secondly, similar to Rob's, I would have asked, so I would love to have a pupillage now. I would learn so much from a pupillage now. Because I think when you're a pupil, you don't know what you don't know. I now very much know what I don't know, and I would like to know it. So I wish I'd asked more questions Like, it occurred to me the other day, I never asked one of my supervisors how he prepped his cross-examination. Why did I not do that? You know, just ask more questions and use it so much, because I would love to have a pupillage now. So yeah.
Go on, Natasha. We'll give Annette the last word, so you need to go first.
I would probably have a chat with myself just after I got taken on in Chambers, because I spent about 3 years just solidly working and not taking any time off, and then went completely the opposite way and decided that actually 3 months a year was the way to do it. I probably just talked myself into taking at least a month a year off and having a nice time, particularly because there's a pandemic coming and it's going to ruin all of my plans.
So if you could go back in time, you would predict COVID and
Yeah.
tell yourself to predict COVID.
I wouldn't warn anyone about anything. It would just be so I could go on holiday and make sure I got enough holiday in preparation.
Go on, Mrs. B. You can have the last word.
Well, if I was talking to my younger self, I would say learn how to herd cats. That's what it would be.
You're pretty good at that. All right, fantastic. Can I just say thanks to all 5 of you, and also to Emily and Hannah in the background, who were always there at these things, making sure everything runs smoothly. Probably have absolutely no interest in hearing me bang on about the same stuff I always bang on about. So thanks to them. Thanks to all of you for attending. I can see that we've actually managed to hold on to almost everyone. I think only 4 people have actually just given up and gone to have some fish and chips or a glass of wine or something. But I know you're all busy, so I'm going to say goodbye and thank you again for joining us. And with that, we'll say goodbye.
Bye-bye.